So we're back with our second podcast with Atul Gupta from Trilegal in India. And today we're speaking about the end of employment.
Yes, that's right. So Atul, some questions about how people approach things when we come to end employment. Kicking that off, what protections against dismissal do employees in India enjoy that employers need to be aware of?
So Tim, this is one of the areas where most organizations looking to do business in India or hire employees in India, right, are most curious about. Now, in India, courts have consistently held that termination of employment has to be for a reasonable cause. Right? Now, unlike countries like the US, Indian courts do not recognize the concept of at-will employment or termination. So there has to be legitimate grounds such as employee misconduct, poor performance, loss of faith, genuine business redundancy, etc. Right? Before they can be a termination of employment. Now, in India, terminations and the approach to termination depends on a variety of factors. Right? One is the nature or the cause of the termination itself, and that's where terminations are typically grouped as either termination simpliciter or stigmatic terminations. Now, termination simpliciter is essentially a termination which is largely for business reasons, and it's not usually a reason which is attributable to be a sort of stigmatized behavior of an employee, for example, misconduct. So you would find matters like redundancy, poor performance, a loss of faith, even continued ill health, falling into the bucket of simpliciter terminations, right? Now, each of these will have further rules and procedures around how you would approach a redundancy termination. For example, if you're dealing with protected workers under the Industrial Disputes Act, right, to make them redundant, you need to follow the last in, first out rule. If someone has worked for 240 days or more, they need to be given a minimum 1 month notice of payment till due thereof. They need to be paid a retrenchment compensation before their last date of employment. Intimations must be filed to the government authorities, right? In some industries in India, in fact, and I would say India is probably one of the only few countries in the world where something like this applies. You actually cannot make people redundant and terminate them as a termination simpliciter even in certain industries. So in factories, mines and plantations in India, which employ 100 or more workmen, and this limit is 300 in some Indian states, the organization simply cannot retrench a worker without prior government permission, right? So this is something that organizations need to be mindful of. And this is a very major protection that is available to certain protected classes of workers in India. Now, the other forms of simpliciter termination would be things like poor performance, where, again, it's driven by court-evolved jurisprudence mostly, where courts have said that, if someone is a poor performer, you need to first give them clear performance criteria, highlight what areas they're lacking in, give them an opportunity to improve before you can actually move forward with a fair termination on this grounds. I also talked about loss of faith, where this is usually applicable for people in slightly more senior positions who you can argue are holding positions of trust and confidence, right? And if they do something or they don't do something which shakes that organization's faith or confidence in them, then it could be a just ground for termination on these grounds, right? Indian law also specifically recognizes that continued ill health could be a fair and a reasonable ground to retrench a worker. In fact, it's treated as an exception from the definition of retrenchment, right? So you don't have to pay them compensation for it as well. But what amounts to legitimate continued ill health is again very subjective. Courts generally view it to be something which is sufficiently, an illness which is sufficiently long and which affects the discharge of the normal duties of an employee, right? So some intermittent illness which might repeat and come and go might not necessarily fit that bill. Correct. So these are the grounds on which you would find that there could be termination simpliciter, which is typically for notice, with notice and with compensation, right? And this is viewed as a reasonable cause. Apart from this, there is also something known as stigmatic termination, which is essentially a termination for misconduct, right? Where there is a sort of clear and established violation of contractual terms or policies. Now, because of the very nature of this kind of termination, where an employee potentially stands to be blacklisted, there are precautions that courts have essentially promulgated through jurisprudence to say that if you were to dismiss someone, and where there is a dismissal for misconduct, you could potentially harm someone's future job prospects, it then needs to be backed by a fair process, right? Rules of natural justice, as they're called, have to be followed, which would typically involve steps like conducting an investigation, issuing a charge sheet to an employee, conducting a disciplinary inquiry through an independent inquiry officer, etc. So obviously, these types of terminations are harder to do, could be riskier as well, especially if you're dealing with workman category employees. There might be an argument to make that if an individual is not protected by any state or central labor law, they're not a workman, right? Largely, maybe they fall into a management category, that you don't necessarily need to follow these elaborate procedures to dismiss them, right? But again, it's a very case-specific assessment. So that's a quick summary of what are the sort of protections that you would find under Indian law. You need to have reasonable cause, and if you are terminating for misconduct, which is also a reasonable cause, then there have to be more elaborate disciplinary proceedings that have to be conducted.
Understood. That's a very helpful overview. And just to, I suppose, just to always helpful to sort of compare to our own jurisdiction and understand the sort of comparators. So in the UK, where an employee has a certain length of service, so 2 years of service, they have protection against what we call unfair dismissal. And basically, this means there are limited circumstances in which a termination can be made, and the employer needs to go through a fair process, and compensation is capped at a set amount, the lower of a year's money, or around £90,000. And because of that cap on the compensation, employees often bring claims for discrimination, which is an uncapped claim here, to maximize their potential compensation. And so I was just wondering, do you have, I suppose, two parts, do you have similar unfair dismissal laws in India, possible caps, and do you have the same sort of issue around discrimination claims being brought in India as well, to try to increase pressure and maximize potential compensation?
Yeah, so Tim, I think that's a very interesting question, and Indian law and jurisprudence hasn't evolved to this level really, right? So there aren't these types of monetary caps in India, which would potentially incentivize an individual to try and pursue other types of claims, such as a discrimination claim, right? To try and maximize the compensation that they would get. In India, the jurisprudence and the law is relatively more simpler. You largely look at whether or not an employee is protected by a state or a central labor law, such as the State-Specific Shops and Establishments Act or the Industry Disputes Act. If they are, right, and then subject to state-specific rules, they could bring a claim of unfair termination and seek reinstatement into their employment with back wages as a remedy, right? And there isn't really any sort of monetary cap as to what those back wages might be. So we find that sometimes claims for unfair termination are made several years later, even though there is a limitation period. That limitation period often gets condoned by courts, right? But we often find that people bring such claims several years later. The disputes themselves take a couple of years to conclude, and you might land in a situation where 5-7 years down, you are required to reinstate an employee with back wages, right? So for the protected category, and again, it can be a very state-specific assessment as to what is the level of remedy I can see. But generally speaking, they could claim reinstatement into their past employment with their back wages. There's a couple of caveats, of course. If you've been actively employed somewhere else while you were pursuing this dispute, you might not have the ability to claim reinstatement or full back wages, correct? But there isn't a cap, a monetary cap on the kind of compensation that you would typically find people can see if they are a protected category. So we don't also therefore see an offshoot of discrimination claims arising in India. Now, for the people who aren't really protected by any of these labor statutes, which again, as a very broad generalization, would largely cover people in core supervisory or managerial functions, right? Those individuals would often just have the ability to institute a civil suit, right? Alleging that their termination was fair or malified, or they were victimized and the employer did not act in a fair and equitable manner. So they would largely attempt to claim that there was some form of breach of contract or inequitable conduct, and the compensation that would be awarded would be driven by various general principles around whether they're able to prove those damages and other equitable principles, right? Again, there's no real monetary cap, but I haven't seen courts in India normally award very massive amounts as compensation, right? So while the law can be fairly sort of pro-employee, the overall dispute resolution process in India might be argued to be slightly more favorable to an employer eventually.
That's really interesting, actually, particularly the protected group, where they can be obviously reinstated even after several years of back pay. We do have the concept of reinstatement, but it's very, very rarely used in the UK. So that is really interesting. And just touching on something you mentioned before about kind of conduct dismissals and having to go through a process, are there circumstances where an employer can terminate, we would say for cause in the UK, well, broadly say for cause, it's kind of summary dismissal, so terminate without notice immediately in circumstances such as kind of, we call it gross misconduct? Do you have a similar thing in India?
Yeah, that's right, Ailey. So we do have that concept. It's recognized under law, and one of the exceptions to what amounts to retrenchment, whereby I don't have to compensate an employer, give them notice or pay in lieu of notices, where they have committed misconduct. Now, what amounts to misconduct, therefore, has to be carefully defined by organizations. There have been some judgments and rulings which have said that if you've not clearly communicated to employees upfront that certain actions would result in termination, in other words, could be viewed as misconduct and could result in termination, then your attempt to do so is potentially flawed. So it's very important, therefore, that organizations sort of, as I was alluding to earlier as well, build in clear termination provisions in their contracts and policies. I've seen organizations go into painstaking detail of what they view to be misconduct in light of the nature of their operations, right? And clearly define that, if there are certain types of misconducts, then we reserve the right to terminate you and dismiss you from your employment without any notice of payment in lieu thereof. Because employees stand to potentially lose out other forms of compensation as well, like retrenchment compensation. You have to be cautious that you view any such termination in a fair and equitable manner. You follow the rules of natural justice and do the necessary disciplinary proceedings, at least for the workman category employees. Correct. For the non-workmen, the non-protected categories, you might have a little bit more leeway on how you approach such exits. But it's advisable to build clear policies around these, right? So that you don't get hit by unnecessary unfair termination and dismissal claims.
that makes sense. That's really helpful. And then in the UK, separate to the unfair dismissal protections, an employer needs to comply with the terms of the contract of employment with the employee. And so usually this requires notice to be given, unless it's, as I say, summary dismissal. But the contract, we often see contracts give the employer the right to place an employee on garden leave or to pay in lieu of the notice. Do you have similar concepts in India?
Yeah, so again, these aren't really statutorily provided for, concepts like garden leave at least. It's fairly common to see that an employer may not require an employee to serve out his or her notice period in case of a termination, and they can buy out that notice period, assuming it's sort of like a simplicity termination. But most state labor laws and even the Central Industrial Disputes Law do prescribe certain minimum notice periods that you have to provide to the protected categories of employees who have the minimum qualifying tenure, which is usually, depending on the law, anywhere from 6 months to 240 days or more, right? So you have to ensure that you are, in case of simplicity terminations, giving them that minimum notice or paying them a little thereof. Now, as I mentioned earlier, termination for misconduct could be without that notice of compensation either. Now, there's no concept of gardening leave under law, but these are very commonly seen and included, and we recommend that organizations include them into employment contracts because they serve a very useful purpose, especially in light of the fact that post-separation non-compete provisions are unenforceable in the Indian context. So a gardening leave provision, which is sort of reasonable in terms of duration and which sort of runs in parallel to, let's say, an employee's notice period, has a very good chance of being enforced in India, right? There are limited judgments around the concept of gardening leave. There's one Mumbai High Court ruling where an organization attempted to essentially couch their post-separation non-compete as a gardening leave, and they said that once your employment ends, you will be on gardening leave for the next, I think, 6 to 8 months. Court said that no, once your employment has ended, you can't then put someone on a gardening leave. But you could read that to me that a gardening leave that continues to subsist while an employee is still working, still employed, is maybe serving out their notice period, has a better chance of being upheld in the Indian context.
That's great. Thank you, Atul. Just, I know we touched on a little bit earlier, so apologies to be going back, but we touched a little bit on the idea of certain people potentially being reinstated following termination. But can we talk a bit about groups of employees who might have special protections against dismissal and who they are and what protections they have?
Yeah, Tim, that's again a very important factor that companies need to bear in mind while they are carrying out terminations for varying causes, right? It could be simplicity termination, it could be dismissal. Now, so for example, employees are protected from termination during the tenure of their maternity benefit under the Indian maternity benefit law, right? So you cannot then, let's say a woman has delivered a child and is in the midst of a maternity leave, you cannot then serve her a notice of termination during that period, or even serve her a notice of termination before she's commenced her maternity leave, if that notice were to take effect when her maternity benefit were to begin, correct? So there is an express bar on such terminations under the Maternity Benefit Act, with some exceptions for very gross identified misconduct. There are certain categories of employees in India, typically those, again, the wage thresholds varies from time to time, but currently the wage threshold is INR 21,000 a month, which is roughly about 210 British pounds a month. Those earning below this threshold have certain benefits under a law known as the Employee State Insurance Act. So an employee, if he or she is receiving a sickness benefit or a maternity benefit or a disabled benefit under this law, I'll call it the ESI Act for short, then his or her employment cannot be terminated during such period either. Right now, if they are under a medical treatment for sickness under the ESI Act, then their employment cannot be terminated until a period of, I think, 6 months after the treatment has been completed. In certain ailments, this could be a longer period, right? There is also the Industrial Disputes Act, which defines certain protected categories of workers. There's a specific definition of who amounts to a protected workman when there is a ongoing dispute, let's say, between an organization and its workers, right? So workers who are recognized to be members of the executive or office bearers of a registered trade union, right, in connection with an establishment, have a protected category. And those types of workers, and otherwise also workers in general, there could be limitations on altering their adversely altering their conditions of service during the pendency of disputes, including dismissal or discharges or punishments, right? So these are the types of individuals that you need to be mindful of, right, who might claim some form of protection from terminations. And you need to plan your exercises, therefore, keeping these types of limitations in mind.
Yeah, no, I can see that. It needs quite a bit of care, doesn't it, in that situation? And I suppose another environment I'm thinking about is things like works councils and employee representative bodies. Now, to what extent do employers need to involve those organizations, works councils, employee bodies, when thinking about dismissing an employee?
So this isn't really something that you would see commonly in India, and there isn't really a statutory requirement either to engage with works councils or representative bodies. Unless, of course, you happen to have like a recognized union and you have some form of settlement agreement with them, which creates such an obligation on you, right? Now, generally speaking, termination of employees in a manufacturing environment with unions is harder than where you might not be dealing with unions, because very often unions, even though they might not have a right to be consulted before any workman is terminated or not, often will question, challenge, or protest a termination if they think that it was unfair, right? So even in the absence of a positive obligation under the law, we do often see practically, and again, this is very specific to sectors or industries where you might have unions, right? We do often see practically that organizations will consult and coordinate with their unions before taking any such aggressive measures. Right. And of course, this is also a factor of what your sort of overall relationship with those unions are, how supportive they are, and how sort of, pragmatic they are towards ensuring, fair and ongoing operations. So that's what I would say towards consulting requirements. As I was mentioning earlier, India is probably one of the only few countries in the world where there is a prior obligation on certain classes of industries to seek prior government permission before they can retrench any worker. This makes it practically impossible for them to carry out any form of a termination in India, right? Because such permissions are never easy or forthcoming. In that situation, what we do often see is that organizations then actively consult with employees or their representative bodies to roll out voluntary retirement schemes, right, where essentially they offer additional compensation to employees to voluntarily, depart from an organization in exchange for that incremental money.
That's really helpful. Thank you. And just finally, so let's say we've dismissed an employee and they're starting to bring a claim. What practical steps should employers think about when trying to resolve termination disputes in India? for example, can you offer a severance package in return for a waiver of claims under a settlement, as you would in the UK?
So, I guess this would depend on whether you're trying to settle after you've already made a termination and you're already at a stage of some form of dispute. In which case, in India, typically, if a workman were to, let's say, challenge a termination as a first step, they would go to a conciliation officer appointed under the law, who would attempt to try and settle the matter between the parties, which is a good stage to try and come to a settlement, right? And that could be a documented settlement where you agree to maybe compensate the individual and get a sort of formal settlement agreement recorded and put into place, right? But whether or not you in fact want to do that would be very, matter and fact specific. We've seen some organizations say that we felt how we've acted is right, and we cannot be seen as paying more money to an individual for a fair termination. So we're going to dispute it, right? So the settlement before the conciliation officer fails, and the matter then proceeds to the next level before an industrial court for adjudication. But let's say, you're at the planning stage, you haven't really yet carried out the termination itself, then yes, we do often examine the background and advise organizations that instead of carrying out, let's say, unilateral terminations or dismissals, you could look at alternate strategies for exit, essentially managed exits, where you would have conversations with the impacted employees, inform them of the reasons for the anticipated terminations, which could be a redundancy or a non-performance or apprehensions of misconduct, and try and examine if there can be an option for an amicable exit through a resignation or a mutual separation, right? Not always, but often employees also prefer such an outcome because it gives them the ability to move out smoothly from an organization. It doesn't potentially impact any future employment opportunities, right? But these types of exits would then typically also come at a slightly higher cost for an organization, because you would then be documenting a sort of a separation agreement, seeking a waiver and release of claims, right? You would have to offer them some additional compensation as consideration for this. Now, such waivers, mind you, might not be 100% enforceable. At least, they might be enforceable to the extent of waivers or releases involving sort of any contractual entitlements, but you could not potentially, let's say, get a waiver telling an employee that I'm waiving my statutory right to a certain compensation or a benefit, right? So those might not really work. So, if you do realize that, you might be better off, given the size, scale, or the reasons for the exits, to carry out such managed exits, then you should plan for that in advance. Try and, of course, build up a strong case to carry out a unilateral termination if the conversation for a managed exit doesn't go well. So I think that's a very important step. But if it is warranted, then these types of exits can work to achieve a separation more smoothly, more amicably, and without sort of, the ensuing worry of a dispute hanging on the organization, right? One other area where I do see these types of managed exits being adopted more often than not is for board level hires, directors, because under the Indian Companies Act, termination of directors can be a little bit more, procedure driven. You might need board and shareholders approvals, correct? So if you want to avoid going down that path, having public records of shareholders meetings or board meetings where you're sort of justifying terminations, right? You might want to look at a managed exit process instead.
That's great. Thank you, Atul. That's been really helpful. So that concludes our second podcast in this series. And please do join us in the next podcast, where we'll be covering other key employment law topics in India.